Repeat after next time. A very good evening to all of you. So we start the third session of the workshop that's on consumer protection in digital era. And I would like to call Professor G.V. Reddy, Professor of Law at Osmania University, the chair for the session, to be seated here. I would like to invite Professor K.V. Sharma sir to present a sapling along with a resource kit to Professor Reddy. Another speaker for the third session is Dr. Veena, Associate Professor at ICFI Law School, Hyderabad. I'd like to invite Professor Keshwar Rao sir to present a sapling and a resource kit to ma'am. Thank you so much, sir. Thank you, ma'am. We would now commence the session, and I would like to invite Professor G.V. Reddy, sir, to address the gathering. So you can also do it from here. All right.
Very good afternoon, or should I say good evening? The dignitaries present, Professor K.V. Sharma garu, Professor Rajan Prasad, Professor Keshwar Rao garu, all the other dignitaries, participants and friends. Speaking at this hour is a challenging task, especially after two technical sessions are already concluded. Nonetheless, since my topic is something different, I think myself and Dr. Veena can throw some light on some of the aspects relating to the consumer protection in digital era. In order to prepare for this small presentation, because I have been given only 15 minutes, therefore, I was going through some literature yesterday, and I was really surprised to read a judgment of the National Commission for Consumer Redressal relating to e-commerce, which is part of consumer protection in digital era. One person ordered a mobile phone for about 9,100 rupees. Then within 2 days from the delivery, it seems the device started getting heated. Therefore, he wanted to get the refund for the said mobile phone. He purchased it through Amazon. And when he asked for the refund, the portal was not supporting his request. Therefore, he called the customer care. Then the customer care person informed him that the policy has been revised. Now there is no refund. There is only exchange. Against that, he straight away approached the National Commission. And you know the monetary jurisdiction of National Commission. Is it more than 10 crores, sir? And he claimed the damages worth 743.9 crores. That's the point. There are 2 points, I think, which we can highlight here. One is the abrupt change in the policy of Amazon or the seller regarding the refund policy. Second one is about how clever probably the counsel for the complainant was to raise the quantum of damages claimed to 743 crores. And the National Commission said there is no reasonable evidence to support his claim, only to, in fact, acquire the jurisdiction. To get the jurisdiction, they in fact, inflated the claim to an extent of 743 crores. So this is one development, which struck me really strange. And I thought that I will start with this small explanation. Anyway, I don't think he got any relief in that regard. Well, coming to the consumer protection in digital era, as all of us know, 2019 Consumer Protection Act is well equipped to deal with the various complaints regarding the defect in goods and deficiency in services, as far as even electronic commerce is concerned. And if you look at the regulatory landscape, there are so many rules, guidelines under different laws. Whether it is the Information Technology Act, we talk about something like Safe Harbor Clause. I'll come to that, Section 79 or so. Then we have the Competition Commission of India, which is talking about the abuse of dominance. There are any number of cases even in the digital world. If we are looking at the Central Consumer Protection Authority, then we have number of guidelines and also the rules. Then we have the e-commerce rules of 2020. We have so many. But let's look at the kind of business or the transactions which are carried out as far as the e-commerce is concerned. And today, when we look at the e-commerce platforms or the important stakeholders, we look at Flipkart taking care of nearly 48% of the transactions, followed by Meesho, or maybe the most preferred destination happens to be Amazon. But if you look at the number of transactions, Flipkart has already, in fact, overtaken the other platforms. This is one important aspect. And during the last few years, I have a few statistics here. As far as the growing economies in the world are concerned, India is standing at 5th position today as of 2023. Then when we are talking about the several sectors which are contributing to the economic growth of the country, e-commerce is one of them, undeniably. Then today, I think we have nearly 150 crores people, out of which 185 million online shoppers are found. So 18.5 crores. Maybe, this is less, and by the end of 2027, it is going to be multiplied. But as of now, it is 18.5. Then when we are looking at the business to commerce, consumer e-commerce, B2C model, this is rapidly increasing day by day. And whether it is the electronics or living appliances, health and other categories, and India is recording the highest number of sales. And when we look at the last 5 years, we find that I'm talking about US billion dollars. In 2019, the gross merchandise value of e-commerce in India was around 22 billion US dollars. And in 2020, $25 billion. In 2021, $36 billion. 2022, $49 billion. And during 2023, $60 billion. In the process, there are number of persons who must have suffered from either defect in goods or deficiency in services or similar, in fact, problems faced by the regular consumers, not necessarily the, in fact, the e-consumers as part of the e-commerce. This is one important aspect. When we look at the legislative landscape, I already mentioned we have the IT Act. We don't have a specific law relating to e-commerce. No doubt we say something about UNCITRAL model being the basis of Information Technology Act 2000, fine. But that is not, in fact, a single window agency alone or single window law. We are talking about the, in fact, the safe harbor clause in a little while from now. Then we have e-commerce rules 2000. I think they are occupying the primary field. Then we have the information technology intermediary guidelines, originally 2011. Now we have 2021. And also digital media ethics code. This is another very important aspect. Then we have certain guidelines issued by the Central Consumer Protection Authority. We call them guidelines for prevention and regulation of dark patterns 2023. What are dark patterns? We can discuss in a little while from now. Then again, we have the guidelines on prevention of misleading advertisements. We call them puffed up advertisements. And I think we are the worst victims of that. And when we are trying to book a flight ticket, then we are coerced. We are psychologically probably forced to book a particular ticket saying that only 2 tickets are left. Same is the case with hotels also. We have seen that. And we have these, in fact, guidelines issued by CCPA on 9th June 2022, talking about the prevention of misleading advertisements and endorsements for misleading advertisements. I think even celebrities are facing the music now. This is one good thing. And everyone wants to be fair and lovely. But fair and lovely has disappeared. Now it is glow and lovely. What's the reason? Because this fair and lovely faced a backlash in US, especially from the, in fact, an organization like Black Lives Matter. And ultimately, Hindustan Unilever Limited had to change fair and lovely to glow and lovely. And today, probably, a little solace has been given, but nonetheless, in the, electronic market, there are any number of people who are ready to purchase anything which is advertised, whether it is false or, in fact, true. My mother is 80 years old, as is common with the people of that particular age. She suffers from the knee pains. And whichever advertisement says that knee pains will be brought down by, using so and so oil or otherwise, she has that agenda ready for me. She says, go and purchase it. And when I always say, don't do that, you can't apply all those ointment, this and that, then you know very well, because they are like almost children. We have to convince them. So orthopedic surgeon or someone else is better off to consult. And same thing happens in almost every household because of these puffed up advertisements, misleading advertisements. And for example, dark patterns, that is in the electronic market, e-market, dark patterns include creation of false urgency. False urgency is created. For example, only 2 rooms left. 30 others are looking in this right now. We are booking a, hotel room. Then only 2 rooms left. Then we are forced. And probably we don't have a clear choice. Or similarly, basket snacking is there. There is something like basket snacking, which is nothing but inclusion of additional items such as products, services, payments, so on and so forth. While booking, we don't come across these things. When we check into the hotel, when we have a wonderful refrigerator over there and a basket of so many snacks, and many people without realizing that we have to pay for them, they consume. And at the time of billing, I think we are required to pay. So this is a surprise, not a pleasant surprise. And again, there is something like a misleading advertisement here. IAS coaching centers are not an exception from this. And in fact, the CCPA, the Central Consumer Protection Authority, has issued 20 notices to IAS coaching institutes for misleading advertisements and imposed penalties on 8 such IAS coaching institutes. So this is dated, in fact, this press release was given by Press Information Bureau, 13th December 2023, hardly 3 months back. Therefore, what we have to understand is that there are number of provisions, number of sanctions, even in the e-commerce sphere, whether it is the Central Consumer Protection Authority's powers, which is the in fact super regulator, super authority. Then we are talking about the Consumer Disputes Redressal Commissions. About that you must have discussed a lot. Then we are talking about the issue of corrective advertisement, which is quite rare nowadays. False advertisement is given, but I think the correction is very rare. When you look at Section 39 of the Consumer Protection Act 2019, we have a mechanism over there. Similarly, cease and desist, maybe Fair and Lovely is one example. As far as Hindustan Lever is concerned, now it has become Glow and Lovely. But in other cases, we haven't seen. Then there is a punishment for false and misleading advertisements. Again, we are looking at imprisonment. I have not come across any person being imprisoned in recent times. Very rare, phenomenon. Similarly, fine up to 10 lakh rupees, which might go up to 50 lakh rupees in the case of frequent, such commissions. Then I already mentioned about the 2022 guidelines issued by CCPA, like bait advertisements or even surrogate advertisements. Everyone knows surrogate advertisements. So McDowell probably can't directly advertise their actual products. So we talk about, maybe cool drinks, some other aerated water, this and that. And we are the regular victims of these surrogate advertisements. And all these things happen mostly in the field of digital world. And consumer protection in the digital world is something, in fact, which is posing number of challenges. I mentioned about the safe harbor clause. IT Act 2000 has the safe harbor clause. At the same time, there is no blanket immunity to the internet service providers, whether they are the network service providers or others. And recently I've read somewhere that if any product is sold through that service provider by using the services of service provider, if the country of origin or the country of manufacture is not mentioned, you can make even service provider liable. I think this is something which was decided by a district forum in Hyderabad, not anywhere else. In Hyderabad itself, one of the district forums appears to have given a decision. And in USA, there was an experiment like Napster, and ultimately Napster had to close down its operations because the service provider washed off its hands, saying that we are simply providing exchange of information. As far as the music lovers are concerned, they can exchange information relating to their music files, MP3 files. After that, they are exchanging MP3 files. I'm not doing anything. I'm simply, facilitating the transfer. This may not be the case every time. I think Section 79 requires a fresh look. That's what I feel. And there are a number of other issues, including the jurisdiction issue, the jurisdiction with regard to the e-commerce transactions. So whether it is the place where the e-commerce transaction takes place, or is it the place where the business is carried out, a registered office is situated? I think now the position is well settled. And now the consumers are in a better position to initiate complaints wherever they reside. So these are some of the important issues. I'm sure that Dr. Veena will cover many more areas. I'm just, flagging out some of the important issues which may not be new to all of you. You must have encountered or dealt with these issues in the past. But with these few preliminary observations, I would like to close here. And I thank the organizers for giving me this wonderful opportunity. Thank you so much.
Thank you so much, sir. I'd like to call upon Dr. Veena uh, as the first speaker of the session. Just, yeah, I will. Yeah, yes, yes.
Respected Chair Professor Sharma sir, Chair of the session, G.V. Reddy sir, dignitaries and other participants who are present here. So I'm fortunate today to present a small views of mine on this before my teachers. So I'm little nervous at the same time confident. So any mistakes if I make, so there are people to correct me. So I'm happy in that way. At the same time, here being a last speaker, there is another advantage because there will not be left anything to cover. Everything has been dealt by all the speakers since morning, but still little 5 to 10 minutes, I just throw upon certain recent cases pertaining to e-commerce. See, after introduction of this consumer protection e-commerce, the rules which have been already implemented. No, this is, I need to. See, we are all in the digital and information age. Right side. Okay, okay. అది రాలేదు ఇంతకు ముందు. Okay. I'll just see. Okay. Okay, fine. Thank you. See, we are very much in the information and technological and digital age, so I need not discuss about that. And how this digital transformation has been taken place, we know very well. And we are totally twined with various technological the advancements taking place. See, from paper to pen, even though we are using the paper pen, we know that how busy we are with the technological devices, Wi-Fi and all those things, because there are so many things which we are recording and all those things. So we have moved from paper pen to the digital devices. And now even the companies, when we look at it, they are leveraging mostly on the e-commerce platforms as we have been stated. And there are so many operational experiences for the efficient platforms which have been providing. And it has been a convenient to the consumers also when we look at it as a positive side of it. And why these e-commerce rules have come, just in a little while we'll look into it. And as we have seen this advent of technologies from the internet which have been introduced since 1991, even though we have, as I stated, that Information Technology Act has come in 2000 and hurriedly we have been come up with because of e-commerce, e-governance and cyber frauds, but later it has been amended in 2008 and how it was an arrayed legislation, we all are very well aware of it. Now, when we look at these things, see, we are finding it very convenient when we look at the online platforms because it has reduced the cost, we need it is time and all those things, we need not go, but we never get the feel of that physically verifying the product and buying it. Definitely that dissatisfaction is always there. But now with respect to even the transactions, not only online, when we look at there is a digital transactions also has been increased because of the technology. And when we say digital India, make in India, and even everyone who is literate or illiterate, that UPI payments, Google Pay, everyone you ask, so you need not carry any money in your pocket. So even for a 10 rupees tea which we have to see buy on the roadside, so they are just looking at UPI payments and all. So it was very convenient. So digital transactions have been played a very important role when we are talking about, so it's a positive side of it. But when you're looking at the other aspects, see why it has been increased is because they thought when it has been alternate platform provided, it is very convenient. And we have all witnessed, especially with respect to pandemic. So how convenient it was sitting at home, we got every the aspects of the products which we have been received. And we felt initially anything new comes, there is how we have apprehension that there may be a a security breach and all this. But equally we feel that see when they have come up with something, so there may be a even enhanced security protection might have been taken. See the consumer's mindset when we are using it. So when they are providing convenience, they might have taken all the measures. So as I stated, the time saving and management of customer, as sir rightly pointed out with the data, the projection of how e-commerce, which has been increased and the consumers online, if you look at that, the market is expected to grow when we are talking about Indian market in this aspect by 2026. Already we are in 2024. In another 2 years, US dollars 200 billion market we are expecting because of surge in increase in purchase of the online shopping. So when such an increase has been taking place, what are the various the challenges which the customer is facing it? So definitely we are feeling it very convenient and all those things at one stage. But is it free from any technological challenges? See, technology is advantages, but are we free from that? So a consumer who has been ordering for the goods or services which has been rendered, so what will be the various the challenges which have been faced by when we are talking about a consumer protection? So we all are aware of it. Maybe see, as since morning we have been discussing that already one of us have been faced any one of these particular challenges. So no one is an exception when we are making use of these platforms. So facing tough competitions because there are so many the platforms and various entities which have come up into. So we don't know which one is particularly a genuine the platform. So logistic failures and gaps, security breaches, as sir rightly said, and misuse of information. See, the misuse of information, or there is no proper information provided about the products when we are talking about a product liability in the morning and all those things. So how equally, sir, as was Keshor also was telling, that half truth and half lie. So even if you're not mentioning the proper information about the product, so is it amounting to any breach of it or what? And there is a wide gap in the quality of goods and services which have been promised and delivered. We have already faced about it. So as we all have the experience, see, we have ordered the product of one color and it has been delivered a different color. Even though there is a disclaimer states that there is a variation in the color because of the photos which have been displayed. To what extent that disclaimer we would give them right, and how the consumer has to be protected against when we have been already ordered for the price. It's not a free product which have been given to us. And any information provided about these products or the services which have been rendered, is it the information provided is adequate, misleading? So when we are talking about misleading, as sir rightly said here, we are all becoming victims of it. See, because as rightly said that the mother, see, sir's mother who has been, because there is a hope, see, something will work as a miracle. So definitely they feel they wanted to try it. See, especially when a person who is in pain. So here they feel that why we are not allowed to that or apply it. See, forget about with respect to fair and glow or fair and lovely and all those things, which is an external appearance, which may even is a short life, because as we grow and all those things, so that will not remain that beauty aspect of it. But when we are ailing with the sufferings, that always we have a hope that it may be cured. Something may be clicking us to relieve. As we have a doctor with us, he knows very well how the patients come with a hope that okay, see, definitely there will be some relief I get when I visit the doctor. Even see, there may be, I heard with respect to my brother who's been working in PGI, he tells some of the psychology of the patients that once they take the medicine, they feel they are cured. So we are forced to give the sugar pills. So even in the Nimans, because the psychological aspect of the patient is If you've been given a pill, I'm treated well. So doctor has been seen, I have been completely cured. So in such cases, are we call these are the misleadings or essential elements in the perspective of these things? So when we are talking about the services of the doctors, can we call this as a deficiency of service? What is expected by him and what is that has been provided to him? So in such aspects of it, they have been enhancing the mental health, and automatically there may be some instances where they'll be cured of such instances. So there is a good amount of hidden charges, because once we at the time of booking the product and later when we go up to the payment level of it, there will be so many hidden charges which they have been completely providing at the end of it. So there certain charges and cyber frauds when we are all well aware of it. So I don't go into detail of all these things. Just I wanted to mention that what are the various the challenges which we face it. So just run through of it where we are talking about. See, complicated process for return of goods and refund of money. These ways the challenges which have been faced, as rightly in the morning, the ma'am has been discussed, Anitra Rao ma'am, that there was no product which have been returned. So it suffered. See, when they have been got it, but even after persuasion, there was no return, stating that there was no policy and all those things. So initially, the consumers has faced several challenges. So to address these challenges, as we are talking about it, the 1986 Act, when we are dealing with, there was no special mention about it. But ultimately at that time, does we mean that there was no relief to the consumers? So for the breach of contract, even when we talk about the breach of contract, whether that condition has been laid down or not, even to come within the purview of the breach of contract. So that is another angle where they were left with no remedy at all. So some challenges which have been discussed with. So after these things, there was a need felt that even though we have an IT Act where it has not been dealt with e-commerce and or electronic service provider, there it will be intermediate the service intermediaries which have been provided, even though e-commerce has been the main objective of the IT Act. Because of the IT Act, the e-contracts has come into existence by amending the Contract Act. But when we look at the e-commerce, see, first time the definition which have been provided under this act, the need was felt. And here, whatever we are talking about e-commerce, that means whoever is buying and selling of goods or services, including the digital products over a digital or an electronic network. So here, the definitions have been more precise and have been clear to explain about the who has been a service provider and what an e-commerce means. We are not going into details of it just because everyone is aware of these things. So directly, I'm just going and trying to reflect under the consumer protection e-commerce rules. What are those things which have been incorporated and why there was a need felt? As we just dealt earlier with respect to technological challenges which have been faced earlier, these rules have tried to address to some extent. I never say this is a fullest extent they have covered it. Still after this, there are still challenges which have been. So if we critically analyze these things, what challenges we get, we'll just look into it. So as we have seen this, there are various models of the marketplace and inventory models of e-commerce. And where we are talking about the system here, when we look at the rule 2 and 2, it will apply to e-commerce entities that are not established in India but systematically offer goods to consumers in India. But what does systematically offer goods which has not been dealt with? So here, even though they have been provided, but still when there is an ambiguity or not clear, there may be a scope for again the litigation on those elements of it. So these have been given the definitions provided. What is a marketplace e-commerce entity? What is a platform and e-commerce entity? So here two important elements when we look at it. What is e-commerce entity? And the one inventory e-commerce entity. So now what is that liability which has been fixed? When we are talking about the duties of e-commerce entities, see, morning we have discussed with Sale of Goods Act where Sharma sir has been clearly stated there is the duties and the rights with respect to buyers and sellers. But when we are talking about from the consumer point of view here, what are the e-commerce entities which have been offered on the online platform when we are talking about it? So initially we have faced, whenever we ordered, we never have the full information provided on them a mere email would have been given. There were those contact address. So when you have an issues with that, it was not clear where to approach and all those things. It is at your risk which you have been ordered. So to address that, clearly it has been mandated under this e-commerce rules that you need to mention the legal name of the e-commerce entity which have been offering those particular goods, and you have to mention the all information which have been clearly stated along with email address, fax, landline, mobile numbers, customer care, as well as grievance officer. Because there is a, even though when we are talking about grievance mechanism, that is redressal mechanism of three-tier structure, but when we are talking about online, it's clearly an online grievance mechanism has to be provided, because you are offering the goods online, but that forum is always there. It's not, we are not telling that you can enforce your rights with the forums, but before going to it, just like how we have ombudsman in insurance and the banking regulations, so we need to have such grievance mechanism online, where even a simple what we call it as very small issues can be dealt without even approaching to that extent. And it's clearly mentioned that you should not adopt to any unfair trade practices. And not only that, as per the central government, here you have to establish a national consumer helpline. So that means you need to have a grievance mechanism and national consumer helpline as an alternate where you can approach for your grievances. So these are the various duties. So if you are not complying with, definitely you will be a violator, because there are hardly any 8 rules under this, not many, but they have tried to cover vastly of the e-commerce entities duties. So as I told you, the grievance redressal mechanism, how this has to work it. So now every e-commerce entity, it has to establish a grievance redressal mechanism, and they have to make a note of it and have a record that how many complaints or the grievances which they have been received from India, and shall appoint a grievance officer for consumer grievance redressal, and they should display the name, contact details, and designation of such officer on its platform. That means even anyone who is just see ordering the goods or the services on the e-commerce platform, they should know that there is certain mechanism which can be helped. So we are not, see, still have been tested when we look at it as it is, when we look at 2019 enactment, how far this has been, the failure of it has come into existence. I'll deal with another 1 or 2 cases in just last 2-3 minutes, so that these things have been implemented perfectly. So when we discuss with respect to this grievous redressal mechanism, as I stated, here its mandate, which have been under the rules, stated that this grievance officer has to acknowledge any complaint within 48 hours, and that complaint, it has to be redressed within the month of that receival of that particular complaint. So the timelines have been clearly mentioned, as we have been stated. Apart from even in the national and state commission and all those things, what that set timelines, here also it can be. So here, one way it is very clear that it's been a speedy disposal mechanism has been provided. Now, duties of e-commerce entities, when we are talking about more or less the same, the details has to be provided. And whenever we are talking about, because shipment, delivery of the goods from outside, as e-commerce, we are talking about cross-border transactions and all those things. So even details of the importer has to be provided on the website when you are importing the goods. And another important element was, when we are talking about e-commerce entity, if there are no cancellation charges, if it is unilaterally, see, what we call accepting those goods or cancelling, in the same way, when they have been returning the goods, they should not have any charges. So that has been already addressed. And here it has been mandated to the all e-commerce entities that they should not manipulate the price of goods or services that serves them as unreasonable profits. Now, liabilities of marketplace e-commerce entities, more or less the main information which has to be provided pertaining to payment mechanism, even the helpline number. See, when we talk about the security pertaining to when they are been using the payment methods on online, and any charges which have been payable to them, it has to be clearly mentioned online. So more or less the liabilities and duties have been fixed on the e-commerce entities. So whenever we are talking about here, especially when we look at with respect to IPRs, as sir rightly stated, there are various legislations with respect to even see competitive agreements, dominant position in the market and all those things. Here also it is very clear when we are dealing with any copyright, trademark and information technology, all those things, they have to maintain a books or the sellers has to maintain that particular record. We have been already dealt under these things. And here, when we look at the aspect of the description and images of the goods or services, they should be given information that should correspond directly with the appearance of those things and quality purpose. Because as we have dealt with the defect of the goods and deficiency of services, what we are discussing since morning, which is the main crux of the enactment. See, same thing when we look at with respect to sellers, the liabilities has been fixed as see morning. Kakkad sir was telling about the who should be liable when we are talking about the product liability. So it has been fixed on the manufacturers, sellers equally, and even on the what we call it as with respect to inventory e-commerce entities, because as we have dealt with false representation, frivolous claims and all those things where you should not misrepresent the quality and the features of the goods. So these are more or less when we are talking about all the information which has to be provided. And for every complaint which has been raised, a ticket number has to be given, through which the consumer will have a clear the facility where he can track and he can know the status of their complaints. And here the same more or less as I stated about the duties and of it. This is like key highlights when we look at it. To summarize, a product information is mandate, grievance redressal mechanism, counterfeit products, how to impose liability on e-commerce entities, unfair trade practices, which have been for how it has to influence the product prices. When we're talking about a data protection, which will ensure, as I told you in the beginning, but whether literally that has been ensuring and whether the act has been fixing any liability. And when we look at the transparency with respect to refund and the written policies. Now, mostly we say that this Consumer Protection Act is been protecting the interest of the consumers. That is restricting the sellers to post fake review products. Here we see that even though there are fake reviews, because sometimes we come across, we don't know who is giving that review. Is it like one seller is being given the poor reviews of others where the influence in the consumers not to buy the product, or they may be giving the high ranking, whether they're becoming convinced between the sellers and all those things. So that is also another aspect of it. Now, see certain 2-3 cases I'll just deal with how these rules have been implemented even recently. Metis Learning Solutions Private versus Flipkart India Private Limited. Here, this case is mostly dealing with the trademark issue, IPR and all those things, where the plaintiffs were selling the Einstein box that it's a kit where completely for the 1 to 6 years children, the puzzles, rhymes, everything and all those things. And they were like dealing and stated that the Flipkart was selling under the name of the what we call it as Newton's unit, this kit. So Einstein and Newton, they were using the scientist names of it. So now whether using of such names is being allowed, or if they use and it is being protected as the trademark, so that means there will not be other persons will be using their names and all those things. But how it is coming within the purview of this e-commerce rules. See, even though the dispute is pertaining to it, the main contention was they have not been provided the information on the Flipkart as the seller's information has to be provided. As just now we have seen that what all the information has to be provided. So when they have just checked about it, there was mention it's about the seller, retail net against the seller. But once they are clicking about it, there was no information provided. So is it not in contravention with the violation of the consumer that e-commerce rules when we are talking about it. So this was a case which has been dealt. See that the dispute may be different, but here the compliance have been done or not pertaining to the failure of the e-commerce, the entity's duties here. This is one element where they have stated. And this is another case in February which have been dealt with in the state of Karnataka, where it has been stated clearly here, this is under the drugs and cosmetics, where the drug was like Suagara tab. When they were marketing on these things, the question was the inventory e-commerce entity. So who's an inventory e-commerce entity when we look at it? So who owns the products and sell it, like Big Basket is an example, Jabong is an example. So here they stated that even though there is an clear mention of the Snapdeal, another website which have been provided, is it the Snapdeal has complied with the requirements or not when it is being provided? So here they have been clearly stated, being an intermediary, they have been provided. So here they have held with that they have complied it. But initial case, there was no compliance. But here there was a compliance held with respect to e-commerce rules. Now, this has been the recent case when we are talking about every traders and all those things. This is pertaining to, as we were talking about the dominant players, the Flipkart and the Meesho. Here, what they have been discussed here is when they have been projecting their goods on the Meesho, most of the Flipkart and the Meesho, when we look at it, there will be a price discrimination of the products. So even though from website to another website, they have been discussing with that price discrimination, and there may be even sometimes the same the product which have been with the brand name and all those things. So here they ensure that whether there is a details of the sellers of the platform has been given and whether the consumers are aware of the details of the seller. So in that aspect, it has been clearly noted and the seller's obligation has been fulfilled and complied as per the section 8 of the e-commerce rules. So these were some of the cases which we have dealt with. So as I told you with respect, we are as critically analyzing it. If you look at from, we have seen the challenges, and to address those challenges, how this act has come into existence and e-commerce rules have been notified. As we have seen already, like just every act has got two sides of the same. It has been benefit to the consumers. At the same time, there are threats and challenges which we have just seen. If you look at here, the first thing, as I told you last time, systematically provide goods to consumers where it has not been defined. What does systematically? Nowhere it is defined. And when we say users as persons that use a computer resource of an e-commerce entity, so the contention was here, B2B business be covered under the ambit of this act or not, as already GV sir has been addressed for this model about it. And when we are preventing the sellers from posting any fake reviews in the guise of customers, but are we looking at, see, we are talking about preventing sellers from posting fake reviews, but whether the businesses will be prevented from posting reviews on their products or services of other sellers. See, we are talking about their products, any fake reviews, but is the act discussing about that whether they're posting on other sellers, so that here that directly influence the consumers not to go for that product. So automatically you're trying to capture the consumers for your product. So here, even when we look at the privacy issues, it has been missed, even though we are talking about the data privacy has been addressed, but it has a plenty of personal data. But if any data is stolen, who is liable? Is there any responsibility fixed under this? See, nothing the rules have mentioned about it, how it has to be addressed. Now, see, when we talk about this, as I told you, delivery charges, they're exorbitantly, there's no uniformity and there is no maximum limit fixed on it. And as and when they feel like they change the delivery charges and there will be a surge pricing during peak hours. See, they will say, if you have to get within 1 hour, so you have to pay for this. And otherwise you will have a slot of 3 to 4 days of it. So here when we see, as sir said, that the necessity it is being created or urgency to have that. So 3 to 4 days, whether really there is no slot available or not, or they're making us to believe and you have to order that within 1 year. So where you have been. So this is another way of affecting the consumers' rights and interest. And even when we talk about unfair trade practices about the delivery charges, as another one, surge on prices, and another one will be like add-on charges and drip pricing. So what is that drip pricing when we look at it? Here, see additional charges, taxes, fees, which are unavoidable or imposed, disclosed towards the end. When we order the product, they'll show that this product is of 200 rupees or 500 rupees. But when you go for the payment of it, they'll keep on adding to it. So in such cases, this concept is been dealt with as a drip pricing, and that is also has to be addressed. Now, see, these are all as I dealt with. Exceptions and all, sir, has been covered. So now when we look at it, it's a way forward. So as rightly said, the consumer is a king in the market. So earlier it was like KV tempter and all those things. Now he has a better choices and he knows what is to be done. So this Consumer Protection Act is a positive and right direction we can take it, provided certain challenges which we have seen, if it is being addressed, is well and good. And I thank all the organizers for giving me this opportunity. So thank you.
Thank you very much, ma'am. It was a very insightful session. With the ma'am's presentation, we have come to the end of the third and the last technical session of the workshop that was on consumer protection in digital era. So we are hereby starting the valedictory session, and our guests have also arrived. So I'd like to invite the chief guest for the valedictory, Dr. N. Satyanarayana. I'd request Honorable Vice Chancellor, Professor Shri Krishna Deva Rao, sir, to present a small gift to sir. Thank you, sir. I would also like to invite guest of honor, Shri Prabhakar Reddy, sir, and I request Professor Shri Krishna Deva Rao, sir, to present a sapling and a resource kit. I would I would like to invite Professor Shri Krishna Deva Rao, sir, to also preside over the dais. I would request Professor Vidyalata Reddy, Registrar, National Nalsar University of Law, to also preside over the dais. So I take this moment to request Dr. N. Satyanarayan, sir, who happens to be the chairperson for Telangana State Real Estate Regulatory Authority, to address the gathering and share his insights on the theme of the workshop that happens to be consumer protection, precisely Consumer Protection Act of 2019. Please, if you're comfortable there, it's good. You can sit and speak.
Standing position.
Whatever is convenient to you.
Thank you very much, sir. And very good evening to esteemed and our SR is our guru actually, very senior most IAS officer, our respected VC Garu, Earlier, I got the opportunity to meet, and today also, sir was kind enough to enter MOU with our RERA shortly, maybe the next week. So, for that also, I extend profound thanks and gratitude. Our respected Registrar Vidlatha Reddy garu and our sir teacher G.P. Reddy garu. I from the same Osmania University. So, all distinguished judges. Yeah. Distinguished judges, so many are there from the law faculty and the professors, Professor Sharma garu. And thank you for the opportunity. And I was, Dr. Sridhar, I was asking actually, yeah, Sridhar, you are there, whether I can go with presentation. But this is the valedictory. If I go presentation, it may take a lot of time. Ma'am has explained, of course, whole gamut of the consumer protection. Ours is the focused Real Estate Regulation Development Act, which was enacted in 2016. So it came into effect from 1st May of 2016. That is with regard to establishing the institutions like Real Estate Regulatory Authority, then Adjudicating Officer, Chapter 9, and also Appellate Tribunal and Chapter 7, and Central Advisory Committee. So those happened, but many states, it took a lot of time, especially in Telangana, they could establish only 1st July 2023. So they took some 6-7 years. In many states it happened. So the actual, with regard to the interest of the consumer in the real estate sector, especially the obligations and duties of the promoter and the developer and real estate ventures, those, that is the chapter 3, which came into force on the 19th April 2017. And similarly, the rights and responsibility of allot is also the same day, and the penalties and also the compensation. Officers. Now almost maybe 18 states, they established the authorities. But when I came, I was sitting with sir. Sir is asking, are you settled? I am settled, but the institution is not settled. Because to take the sanction of the staff, it takes a lot of time, sir. First point. Second point, it is evolving. This till prior to 2016, this is totally unregulated, except Consumer Protection Act. So no other provision to go. Consumer protection is only to relief. Finally, having roof on the head, whether we get into that, we do not know. That is almost post-mortem. But biopsy type of thing is provided in the our Real Estate Regulation Development Act. Many think by name, because I have been interacting with so many, and recently I had been to Osmania University also. I was interacting with students, and some 30 university 5 years course students, they came. They went by the name, Real Estate Regulation and Development Act 2016. If we see 92 sections in the Act, the real estate regulation and real estate development as such, we do not regulate. These two subjects are exclusive domains of the local authority and the state government. Because, for example, Town Planning Act 1920, that regulates the real estate. For that, state government and the DTCP, HMDA, they are the authorities to such kind of regulation and also to promote development. Then if you see Urban Development Authorities Act 1975, they are also state government and local authorities. And especially for Hyderabad, we see Hyderabad Metropolitan Development Authority 2000 Act 2008, HMD and the government. And our Great Hyderabad Municipal Corporation Act 1955, GHMC and the government. Then if you see the municipalities and corporations, they are the urban centers. You see Warangal, you see Karimnagar. That is, of course, done by Telangana Municipalities Act 2019. In the villages, bigger villages, Telangana Panchayat Raj Act. And also with regard to this, especially the vertical development we see, that is the Telangana Apartments Promotion of Ownership and Participation Act 1987. There also the other government organizations, they are getting involved with regard to regulation development. Then question comes, then what RERA will do? So RERA definitely regulates. It regulates the selling and the transfer of the real estate development products. That means a plot, flat, villa, or apartment. That real estate regulation authorities under Real Estate Regulation Development Act 2016, they will get into that. Here also, for example, someone X is selling the plots without development of the land. This act has no application. For example, somebody is selling the flats without construction or refurbishment or modification. This act has no application. So means it regulates the sale or transfer of the real estate development products with the development and also construction. So whenever they takes up development of the land and the construction of the building with the purpose of sale, this act has application. And in this also, maybe to promote the real estate sector, the government has given, the legislation, it is given some exemption up to 500 square meters. That means 598 square yards. They need not to come to the RERA and register. And for example, it is less than 8 units. They need not to come to us, get registered. Why they need to get registered? Earlier, prior to 2016, there is a asymmetry of information. Ma'am was in our presentation was telling so many say, yeah, nowadays the people more become greedy because of maybe materialistic development. We are actually going down on spiritual development. The values, ethics, etiquette, especially unlike, of course, North India, South India relatively better, but still, if see anything which is becoming a bankrupt, it is because of greediness. They want 10 times, 20 times, that kind of returns they expect. As a result of which, they will resort to that, and they will only exploit the consumer. So considering that aspect, in the real estate, this act provides symmetry of information on specific aspects. There are 12 aspects like Lakshman Rekhas. On that, they should provide a website. And some 6 declarations. This is symmetry of information. Once they are uploaded in our website, we register. Then this promoter or the landowner is also promoter. And here the allottee or the home buyer or the plot buyer and the broker we call. Now he is called real estate agent. The 3 people are accountable. So based on that, we regulate the real estate sector so that we boost the confidence of the home buyer or the plot buyer. Thereby, in turn, it promotes the real estate sector. That is one aspect. In 92 section, there is a section that section 32 says the authority shall promote the growth of the real estate sector. That means we can recommend to the government or the local authority. But finally, whether to accept or not accept, it is with them only. So we only recommend. That means we don't have functional responsibilities with regard to regulation and development of these real estate aspects. Only on the 12 items and 6 declarations. Once they filed, we can register. Then I think it is like a Lakshman Rekha. Both shall be binding, legally binding on the both the developer and the landowner, and also the allottee to some extent with regard to payments and other things, and also real estate agent. Those kind of provisions are given. And after establishment, the RERA in Telangana on 1st July 2023, we had been to about 8 states. So because the authority, now second authority came into operation. First they completed the tenure and second authority they came. That means they evolved, they developed. We studied all most urbanized states of about 8 states in the country. We are just simply following their the present stage of development, almost RERA 2.0 rather. So accordingly, we established the tribunals, and we have taken the minimum required staff because staff sanction is still pending. And not only that, we entered MOUs with all institutions like, for example, IT is concerned. Maharashtra, prior to RE-RD Act 2016, they have their own act. That is the only state in the country. They have their own state act to regulate the real estate and also take up the development of the real estate from the perspective of the consumer or the home buyer. So we followed that, and this IT aspect also we entered MOU with them and also CGG. And additionally, with regard to planning aspect, we entered with Administrative Staff College of India to take required assistance and professionalism in this sector. In addition to that, in this act, there is a provision for conciliation, establishment of conciliation forums. So Maharashtra has actually taken the people from the promoters and also the consumers and formed the conciliation forums and gave the training. And there is a huge work went on. Almost 33% of the cases are getting settled with consumer forums. That is the sustainable rather. Ours is only, it's only adjudicating body. One person will win, one person will lose. Here it is not like that. Conciliation forum will be on a sustainable basis, win-win situation. So thereby we can promote the real estate sector and also the protection of the consumers can be given on a sustainable basis. So same thing we followed, but having the strength of IAMC in Hyderabad, we discussed with them. Luckily, Mediation Act 2023 also came into the legislated. So both put together, we entered MOU. We established the consumer forums with the mediator from the IAMC and also one member from the promoters, one member from the consumers. We have taken the panel. We gave the 2 days training on that aspect, and cases are being referred to them. So that conciliation forums also established. With regard to education, we provided, considering it's only one institution, small institution, very skeletal one, to take care of such a huge activity happening in especially Telangana. Telangana is the most urbanized state. Almost it crossed 43%. Maybe in the other 5-6 years, of course, census is not conducted. In the next census, it will reach around 48%. That is a huge growth. Considering that aspect, only IT is the now available tool to have minimum government and maximum governance. So that for that we provided the online the hearings, and we provided hybrid mode, and accordingly the cases are being dealt because 7 years pendency is there. Almost the pendency we have cleared, but still when you keep doing, there are so many cases keep coming. That is also their extra burden. That is why I requested our respected VC sir to the help of the National Institute of Urban Management for a few aspects, and especially engineering aspects also will get involved, because in this act there is a DLP, defect liability period. Once occupancy certificate is given till 5 years, I think he is responsible for any structural defect and defect in workmanship and also the amenities quality and all that. So considering that only engineering institution help is required, that's why we entered MOU with Engineering Staff College of India. That way we started travel. It's only, we are 7-8 months old. Unfortunately, when we got established, there is a assembly elections, now the parliament elections, because section 33 provides for advocacy and awareness. That is very, very important, crucial and critical. Finally, we should give the strength to the home buyer or the plot buyer or the consumer in the real estate sector. Unless and until we do that, alone we cannot do. You all know, you all appreciate that. Only before we came here in the chamber, we were discussing. The real estate sector is close intimacy with the political parties and all the political sector. This is one of the feeder category. So that is why we should go consciously. If not, it may bounce back or boomerang. So that is why in a constructive way, in a creating conducive environment, we should do. Considering that aspect, I am requesting respected VC sir to help us to take up this awareness and advocacy programs in the, especially the bigger urban centers, including Hyderabad, from June onwards. Maybe with the MOU, we will take it up that. And I request the your expertise also in that in our travel, so that finally in this aspect we can do the right service. Especially on this occasion, my only international national studies says that in our savings, 77% of our savings are spent in the the plot or home purchase. 77% of our savings. Kindly understand, not only the money, and once it get affected, the tremendous mental disturbances that we undergo, that cannot be imagined. So that's why this is the area where I think we need to uh, come together and work on that aspect. So far, there were about 2,000 cases. We could resolve about 1,010 cases, and we are traveling in the path. And especially the Consumer Protection Act 2019 is much wider. It is ours is focused. We need to evolve. There are so many case laws which are coming, especially, for example, we see the recent court ruling have underscored the importance of the providing home buyers with a choice of forum for addressing the disputes with builders. Delhi High Court's the decision affirming the concurrent remedies available under Consumer Protection Act and also RERD Act, Real Estate Regulation and Development Act, uh, is a significant milestone in this regard. It reaffirms the principle of home buyers should have the freedom to select the most appropriate forum at adjudicating their grievances, whether through our RERD Act or the Consumer Protection Act. That kind of aspect is a very useful for especially to the consumers. Like Consumer Protection Act, that kind of paradigm shift we could see with the 2019 Act. If RERD Act 2016 also, now you can see a conspicuous paradigm shift. For example, you can see especially the bigger cities, wherever you go in the country. If you travel, you go to the airport, all the advertisement you can see, the RERA number would be there. If you just click there, you can see with regard to project. On the project also, as I was telling to you, under section 4, they are provided on 12 items the information. 12th is about, of course, declarations. So in the 12th items, for example, that promoter is there. What is his track record for the last 5 years? Second, what are the sanctioned authenticated approvals? And what are the amenities? What are the specifications? What is the land title status and its authentication? Its certification by the advocate having 10 years experience, and timelines on completion, timelines of handover, and his obligations to form the resident welfare association. So because the common amenities need to be transferred. Earlier, there are so many exploitation of the home buyer dealing with the common amenities. They charge and they will exploit. Now it is not possible. And also increases the assertion on the quality of the amenities or the building, because that 5 years DLP, defect liability period, is provided. On that also he has to give the declaration. In addition to that, whatever money he is drawing from the allottees, that is taking from the allottees, 70% shall go into dedicated account for that project. And its drawal must be in proportion to the percentage of the construction. That also based on the certification made by the project engineer, project architect, and the CA in practice of that project. In addition to that, he has to submit after every year annual accounts audited by another CA who is in practice. So those kinds of provisions about 18, 12 plus 6 are provided. So that actually anywhere that number is taken, if you go to our website, you can have that access. You need not ask anyone. That is that kind of transparency and the efficiency with regard to the way the amenities are being provided and the timelines are being provided and the obligations are taken care. So those things will be handy now the consumer to judge about its rate. You need not to stick to this project. You can go to any other project, and that kind of information is provided. That is very clear. Now, the conspicuous development, that change we can see is no project can be launched without RERA registration. No project can be advertised without RERA registration. It is clearly seen. So as I was mentioning about the timelines of the completion, timelines of the handover, timelines of the executing the conveyance deed towards the allottee or the association of allottees with regard to common areas, here very much clearly it is mentioned. If it is delayed, those the reliefs are provided very clearly. So that kind of conspicuous development it is provided. For example, the plot is now agreement of sale is entered. If he wants to make a change in that specific plat. This is a minor. He shall take the consent of the allottee. Without that, he cannot do. If there are additional alterations, he has to take 2/3 allottee's consent, and then he can take it up. For example, this builder or this promoter wish to transfer his majority of shares or majority of assets or liabilities. He has to take through 2/3 consent and also consent approval of the authority. Then only he can go for that. Those kind of provisions now they are very clearly made in the act, and it is being implemented. That kind of paradigm shift with regard to the impact, and it is conspicuous. It is happening, but there is a long way to travel, especially what I was telling to you with regard to finances, with regard to what I mean to say, the operation of the specific account mentioned for the project, whether he is actually, it is provided only 70% of the allottee's money, but there are so many. For bankers' money is not included. It's only the recent legislation, it is getting evolved. Only Central Advisory Committee recently, on February 29th, they conducted the meeting, especially with regard to, there is a little provision given to the builders about the agreement of sale or the sale deed. So they specifically mentioned, but some discretion is given. In that, they are exploiting the allottee. So maybe in the days to come, that also will be addressed. In addition to that, especially Act provides for insurance on the title and also other aspect. Title insurance means very costly. Finally, it will fall on the allottee only. So I think that is the need of the aspect to further study and work on how to go about it, because in the developed countries this provision is, this is happening, but in India it is not there. If you include that, these the prices will go very highly. So that is another aspect, because once the project is started, then the litigation is coming, because of property titleship is not there in India, nowhere. So because of that, so many issues are coming. Because of that, it's getting delayed. And when getting delayed, it is becoming, I think, becoming insolvent. And then they will go to IBC. IBC is the lateral legislation. They prevail over us. That problem is there. And there, of course, recent the Supreme Court, the case law, few aspects they settled. He also be considered as a financial creditor. Once we get into that, I think every home buyer shall be taken care, and you should prevail over the other financial creditors. That kind of ruling is also given. So considering these aspects, thank you very much for providing this kind of facility for the RERA, and also getting involved in this kind of workshop. I think it enlightened only last session I attended. I am fortunate to attend that last session. Other sessions also, it would be, I think, very fortunate our people to attend. But we are only smaller body. We have only now 13 officers, not more than that. Others are only the computer operators and the attenders. So put together, we have only 23, 24. I think we are awaiting the staff sanction. In the meantime, to go along, we are taking the assistance from the institutions I mentioned. Once again, I congratulate and extend profound thanks for getting the for involving us, and also proactively helping us to enter MOU with us and helping in the sector. Thank you so much. Thanks a lot. Sorry?
What action you can initiate at the right?
Yeah, in the violators, a wonderful point he raised. I was mentioning to you, there are three institutions. One is the Real Estate Regulatory Authority. Second is the adjudicating officer. Third is the appellate tribunal. These two now, first this the regulation authority consists of chairman and two members. These are all technical people, no judiciary person. So considering that, there is a adjudicating officer who is a district judge. So in the beginning, maybe in 2017, 18, say there is some confusion with regard to whether this authority can give the refund and also the interest and also the penalty. And fourth one is the compensation. Earlier they used to do. Now it has gone to Supreme Court. Supreme Court settled that issue. So this compensation is by the adjudicating officer only. So as far as authority is concerned, as rightly mentioned, section 18 and 19. So all refunds, the interest and penalty we can give. We can adjudicate, we can give orders. And as far as compensation is concerned, the case will be referred to the adjudicating officer. So section 72, they clearly mentioned 4 aspects. On that, he has to adjudicate the matter and give the compensation. The problem rightly mentioned, we can give orders, but execution it is not there. That is another problem. That is the loophole in that. We have to resort to the Revenue Recovery Act, first point. Second, it is get implemented. I should go to the civil court and get implemented. As far as appellate tribunal is there, they have executive powers. We don't have. As far as adjudicating officer and real estate regulatory authority, we don't have the execution powers. We only again go to the district collector and get it through Revenue Recovery Act. We need to do.
That's next week possibility.
No. It can be done. My point is, for example, I will just tell you. We have taken up after our joining about 37 cases. We imposed penalty of about 22 crores. 13 crores we received. Luckily, in South, more so in our Telugu states, complaints is more. Usually they don't deviate. For example, monthly developers, I imposed 6.8 crores. So already he is a bankrupt and in the jail. The Sushil Mantri and Pratik Mantri, both son and father, are in jail. ED attached properties in Bangalore. So I am little worried. Our people, they came and they told, no, his money is there in HMDA 10 crores. The 600 crores I can take. That is another aspect. Second aspect we have, luckily, it started in 2006, not now. We introduced in Telugu states. I was, that time also I was in the department. So we introduced the mortgage clause. Every property when it takes up construction, for example, in HMD it is 15%, other is 10%. 10% of the property must be mortgaged, entered into POB, private register, by the sub-registrar. So that property with the government, for example, these violations are there, definitely that would be, at the time of completion, this price will go up very exponentially. So usually he doesn't resort to that. He will somehow take the money and give it to us and he will sell away, get it released and sell away. It is happening. That kind of problem, it is not there, first point. Second point, as you rightly mentioned, finally, if you go this kind of thing, this in our traditional legal routes, this escalation is there. No? They will go to appellate tribunal. So for example, to get implemented, I should wait for 60 days. The time is 60 days. So for a home buyer, it is very difficult. For the promoter, he will have a battery of advocates. He is not bothered at all. For him, nothing. But for the home buyer, it is the life. So that is the problem. See, they are not same footing. So your point is well taken. We are agitating for that. We have All India Federation of RERA chairmen. This issue was raised. We actually opposed to the government. Taking amendment is not a small thing, no? Acting amendment. But we should have the execution powers. If not, I think maybe a long way it will get affected. We are getting done, but getting delayed. Delayed is denied, especially for the home buyer. Who will buy at the young age? Maybe 50, 60, they will buy. If it takes 10 years, we will cross 60. That means retired. Retired means we leave it to our son. They are abroad. So so many issues are there. My point is, your point is well taken, and it is required to be there. And so that the immediate, because the Act provides the dispute redressal on 2 aspects. One is cost effective. Second is speedy dispute redressal. You are giving order. Finally, whether getting implemented or not, that is important. Getting order is not important. For a home buyer, for a small person, maybe teacher, maybe the professor or lecturer, for him is a huge money. 50, 60 lakhs is not a small money. So considering that, I think this execution powers are not with our authorities. It need to be there.
We had an interesting discussion on the restoration of conjugal rights.
Acha, okay.
He obtained an order.
Acha. That is the, yeah.
Can be executed, sir. Okay. By attaching property of the default. Property. It's not an.
Thank you so much. Any question? You are most welcome.
Thank you so much, sir. Thank you for highlighting the role and importance of RERA in not only adjudicating the disputes related to real estate, but also the role of the authority in making consumers more aware and protecting their interests. I would now like to invite Sri Prabhakar Reddy, sir, retired IAS officer, who's the guest of honor for the valedictory session, to also share his insights and experiences with all of us.
My colleague Satyanarayana, Vice Chancellor Nalsar, Professor Sudev Rai, and other colleagues, other invitees. Thank you very much for having given this opportunity to me without any subject. So that is it's a very wide way of, I can talk anything and get away. The consumer protection we're all talking about, and you have been deliberating since morning, I understood. Consumer protection is not new. It is there for quite some time, ever since this last 200 years. But it is evolving over a period of time, particularly when the country develops and the commerce develops. This consumer protection gets more relevance, more and more relevance. So that's the reason why in India we have this Consumer Protection Act somewhere in 1986, very late compared to other European countries or American states. That means we are also evolving, and our country is also prospering, and things are going economic way in a better way. So more goods and more services have been offered, and more services have been purchased, and people are buying goods and buying services too. So when the number goes up, the problems come definitely. And when the problems come, what is the problem? What the promise, or what the service, or what the article sold, and what the expectation of the consumer, and how much he paid. Has he got the article or service worth his money? When it fails, then Consumer Protection Act comes into existence. But Consumer Protection Act kanna munde, and before that, there are so many acts. All of them are to protect the consumer. Weights and Measures Act, Food and Adulteration Prevention Act, so many acts are there. All of them are supposed to protect the consumer from exploitation, from deficiency, from misleading advertisements. All of them have got different acts, but still consumer is being sometimes cheated, and he doesn't get redressal. When he has a complaint, he hardly gets any redressal. Number one. Number two, the fight is between, if at all there is any fight between the consumer and the person who's offered or who sold the service or goods. It's like uneven strengths. The person is a big company or a big industrialist or whatever, with a lot of resources, a lot of legal luminaries supporting him. whereas consumer is alone and his stakes are very low and he will never be able to fight. He will never be able to get the complaint or redress. So all these things have given rise to the Act of Consumer Protection. It is all encompassing. Anything, anywhere. If there is a transaction between a customer and a seller or some company, the consumer protection without bothering a law, unlike in a court of law, there the disposal will be quicker, the redressal will be faster, so that the consumer's protection takes place certainly, which otherwise takes years and it may not take at all in the court of law. With the due apologies, not that they do it, but for various reasons there will be tremendous delays and the fight goes on. Whereas the Consumer Protection Act will ensure that the customer is taken care of, customer's complaint is redressed. So over a period of time, it is evolving. Now 86 became 219. And what are the new additions? She was talking about the e-commerce. That so many things are happening. I'm sure the authorities and the acts and the people who are heading them, like Satyanarayana was telling about RERA. RERA is very, very crucial now. It's also evolving act. And he has to ensure that the RERA is actually implemented. See, any other consumer, any other purchase and sale, it may be, the quantum may be small, the price may be small, you may be doing many times the transactions. But when it comes to buying a house, it is lifetime, once only it happens. And you put all your resources and also your future. Future means you borrow a loan and you are supposed to repay till you die. So that bank loans. So that much of enormity is there in the buying of a house. And when something goes wrong, you can imagine the plight of the people. They may offer one thing, they may not be giving you the same thing. So such are the times RERA will have to play a very crucial role. And I wish, as Satyanarayana was telling, he needs more teeth to bite. Yeah, unless he has no teeth, he will never be able to bite. When you can't bite, we know that you can never fight. It's like a dog bites dog like. So the RERA must be strengthened. And also, like any other consumer protection act, like whether it is cyber crime or e-commerce crime or whatever, there the stakes will be smaller. Here the stakes will be very, very high. So whenever the enactment comes, they evolve over a period of time. They take from the experiences and they add the expectations and they create the act, and it will be dynamic. You go on adding and making it more and more powerful. And you all know that if you have a police station and if they work well, there will be less crime. Because people will be afraid of committing any crime when the enforcement authorities are very good. When the enforcement authorities are weak, the people take the chance to commit a crime. So when the RERA is RERA, as well as the implementing that act, as well as the implementers are good, the real estate developers will not take chances. Like that, any enforcement of act or for protection of the consumer, it should have sufficient teeth to bite. And as long as it is there, definitely consumer rights will be protected. And consumer may be anybody, you and me. There is nothing like a separate consumer. Everybody among us is a consumer, is a seller and buyer. So we all will be involved, or we all will be affected. We all wish that the Consumer Protection Act ensures whatever the price we pay and the goods we receive or the services we receive are appropriate or commensurate to the value of the money we pay. That is what I can say. Nothing specifics, but I am happy that this Nalsar Institute took their initiative to conduct this seminar and enlighten people like us. What are the issues involved, and what are the case laws, or what are the experiences? And I am thankful to you. Thank you very much for giving me a chance to be with you today. And I am really enlightened about so many issues which I am not very not aware of them. Thank you very much.
Thank you very much, sir. So, with this, we have almost come to the end of all our sessions. I would request Registrar Ma'am, Vidyadata Reddy Ma'am, to please deliver the vote of thanks to mark the end of the sessions.
Concluding, Professor Sharma should say.
Any
concluding statements? Yeah,
I am so sorry about it, sir.
No. Because we were there in the morning and we had a long discussion. No, I will just say 2 lines. Relearning about consumer protection. We started in the morning with a critical introspection, and we heard many things. And my colleague, Professor Sharma, with all the team, will work on the action points. I'm happy that Vera Satyanarayana Garu is here. We will work together because the new frontiers are opening up in the consumer protection. The conventional consumer protection is into e-commerce, it is into cyber, and it is into real estate and everything. And what I will highlight is one is awareness. Awareness, law colleges has to major role. And how do we move, reach out to the people? Education, awareness, and action. Activism. Lawyers, law teachers have to play a major role, and mediation, conciliation. So we should take the lead. That's what I have been saying in the morning and wherever in the consumer protection. 2019 gives us the gateway. How do we use that? You are all law teachers now. What I call is pull up your sleeves. Sadavandi, law, rules, pronouncements of the judgments, and comparative perspective. You have to take the lead. And then students will come with you. Then you can change. The gaps in the RERA also we can overcome. Whatever is there, it's possible. Primary responsibility on law teachers and the citizens. We have played catalytic role. Thank you.
Thank you.
Teachers,
You want, okay, you want.
Because 4 minutes, and then, yeah. 5 minutes.
First of all, I'm thanking Satyanarayan Garu, Dr. Satyanarayan Garu for coming all the way. Anyhow, it is the duty of Registrar Madam to tell vote of thanks, but as a consumer law chair professor, my duty to thank Satyanarayan Garu and Prabhakar Reddy Garu for sparing their valuable time. Morning, we started with Justice Jaiswal, sir. He is presently the chairperson of Preventive Detention Act Advisory Committee, and he expresses what you call concerns regarding the what you call facilities the government is unable to provide to the consumer protection forums. How many problems the state commission members or district commission members are facing, national commission members, they don't have even stenographer to dictate. Yes, sir, yes, sir. Government is facing and consumer protection authorities are also facing. So, yes, sir. Yes, sir. You are also facing, and state commission members, district commission members, and Pasait committee report explained all these problems. If you go through Justice Pasait committee report, he explained all the problems. And later on in the first session, I think the members they discussed about defect in goods and deficiency of services. Professor Kesara Garu, he explained about misleading advertisements. Then the other 3 members, first member, I think I think morning, Mr. Venkatraman were also Vice Chancellor, National Law School, International Law School, Goa. He also explained about the importance of consumer protection. And Justice Jaishwal Garu also expressed the problem which he faced when he was the president of the State Commission. And in the first session, Professor Rajendra Prasad explained about what we call the about defect in goods and deficiency of services. And Dr. Anita Rao Garu explained about what you call the problems or intricacies in health law, particularly medical negligence and all these. And particularly you explained about this fertility centers and all these about those the cases Madam explained. And Dr. Santosh Kakade explained about the intricacies in Consumer Protection Act. And Balasubramanian explained about the what you call misleading advertisements. Professor Keshwaragan also explained about misleading advertisements. These two topics, these two experts, they covered. And Professor B. Hamalata Devar in session 2 explained about the redressal mechanisms, that is District Commission, State Commission, National Commission, and the loopholes in those. And Madam suggested mediation is the alternative to dispose of the cases. And Dr. P. Vijay Chandra also explained about, I think, sir is here. He also explained about the redressal mechanism of whatever problems that we are facing with reference to. And Dr. P.V.S. Muttigara explained mainly the implementation, what you are telling, sir, execution part. We are getting orders, but execution is very, very difficult. So that area, Dr. Muttigara explained about digital era, consumer protection and digital era. Professor C.B. Reddy and Dr. Veena explained in detail, and all the honorable guests are here. So in these three sessions, these experts they covered first session, what we call defect in goods and deficiency of services. Second session, consumer dispute redressal mechanisms. Third session, consumer protection in digital era. These three areas we covered, sir, and they have given so many suggestions. I requested all the participants to send their suggestions to Consumer Law Chair mail ID so that they will compile all this and will send to central government. And in the valedictory, I thank Satyanarayana Garu to explain about the RERA, importance of RERA and all this. And Prabhakar Reddy Garu explained about the Consumer Protection Act, importance of consumer protection, because in civil courts, it will take decades to decide the matters. And in consumer protection, at least if not 6 months or 180 days, at least in 3 years, 4 years, we are getting some remedy. If and appellate provisions from district junior civil judge to district court to high court to Supreme Court, and it will take some 50 to 80, 100 years to decide the matters. In consumer protection, only one appeal is given because district commission to state commission, one appeal. No second appeal provision is given under the act. State commission to national commission, one appeal. And in case is filed in National Commission to Supreme Court, one appeal only. So at least some relief. If not in 180 days, at least in 2 years, 3 years, the consumers are getting now compared to, and one more advantage under 2019 Act, the consumer can file the case sitting in his house through email also. Or he can file a case in the court where he is residing. So this is one important, what you call, amendment they made in Consumer Protection Act 2019. With these words, I thank all the honorable guests and delegates for attending this particular function and making this function a grand success. Thank you, one and all. Namaskar.
Vijayalata, come to
So I request ma'am to deliver the vote of thanks.
So one more vote of thanks. I think in the valedictory session, I can see the faces of the participants who are here from morning 10. They are like, please spare us. Huh? So I can understand from your faces also like how tired you are. And it is very difficult to listen than to teach. That is one thing all teachers will understand when we attend workshops and conferences without fail. And very surprisingly, 3 former vice chancellors still very keenly following a workshop from morning to evening, taking notes and deliberating. that shows the discipline and the authenticity of the legal academia that we have. And I feel this workshop is successful to ignite that kind of interest among the academics, and we could keep them and discounting other assistant professors or others, they have to learn and evolve. But for the people who have achieved everything also, they, that is what the academics is about. That's where we are distinct from others, and that makes the Nalsar real learning place. And as we know, everybody is a learner till death. That's no doubt about it. But the kind of workshops that we do and the kind of interest with which, the commitment with which we do matters. It's not that you come here, do network, eat and go. That's not the one. But and then you give some suggestions to the ministry and make sure that the law is in the right direction. We take up our commitment in that context is a real worthwhile, and this shows the success. And I really thank our valedictory session guests, Sri Satyanarayan Garu from RERA, as we call it, and morning, as MSK Jaiswal sir was putting forth, that many cases in the consumer forum are related to only three aspects: insurance, construction industry, and medical negligence. So your inputs are from the other side, like what RERA is doing and how important the dispute is for the consumer, because it's his lifetime earnings which are coming there. And we have more responsibility to make sure that the law is very well drafted and executed, and the regulatory authorities does it, and what are their limitations and constraints, and what are the power they have been. We are hearing from the main person, the real thing is a real good insight for us, and we thank you, sir, for giving the insights from that. And
Sure.
Sir.
I only exposure and understanding. Of course, literature also says that this is a lifetime links. Odd, and I feel it is not lifetime, it is a lifestyle. Because I am sitting here, and Professor Krishna Sir is sitting here. We may think that it is our hard work. It's not so. My father, forefather,
yeah,
had if they
yeah.
not done work, we will be
So it's
maybe
like
some
generations,
casual labor in the
yeah.
village. Because they have given some footing.
Correct.
So we are here. Similarly, for example, you are spending 1 crore, investing 1 crore. It has the contribution of your father, grandfather, grandfather.
I'm happy, sir.
Without that base,
I'm happy that a regulator has that, he's so conscious of the value of that. I'm very happy that right people are in right place. That gives thank you. So we wish that under your aegis and some more good is done to the consumers, and the home buyers or whoever has get the benefit of this legislation in a very right perspective, and we could do some amendments if required through our consumer chair, and you can give that insight. I think our working together will have a more brighter future for the people of this country. And I thank our other guest, Sri Prabhakar Reddy Garu. He started off saying that I can speak of anything and go away, but he has actually raised why Consumer Protection Act came up and what was its objective, how much it could reach to the masses in a very right perspective. Thank you for your insight, sir. Thank you, one and all. I don't want to be blamed for being speaking extensively. Thank you.
Thank our colleague.
Yeah, I thank Professor, for this, for organizers. I'm sorry, I thank my colleagues and the entire team of the faculty, support staff, and everybody for making this huge success. And more especially, thanks are due to the chair, Professor Sharma, for taking out all the efforts and pulling, and also please, when you do these conferences, spare us for one for inaugural, one for valedictory. Making VC register for all inaugural and valedictory is like, okay, thank you, sir. Thank you very much. Thank you.
Without the vice chancellor, we can't complete function and we can't start. Once you occupy the place,
Okay, thank you. Thank you very much, sir. Thank you.
you have consumer budget, I have to thank Professor Keshav.
Yeah.
Because of him only this function today, it is successful because of Professor Keshav from last 1 month. The other team, it is not at all, I did not do anything, our Dr. Sridhar and Sharon, then Kiran, and Mallikarjun, these four, they are the backbone of this function, because of them only this function.
Preeti standing.
Madam, anyhow, morning onwards, now, till now, she is working. I'm indebted to you also, madam. Thank you, thank you.
Madam, name your name.
Preeti. Recently, sir, I remember.
Preeti Anand. Preeti Anand. Yeah.
Because she joined in my absence, so.
Yeah.
Thank you. Let us join for IT.
Yeah.
IT is arranged, madam. IT is arranged. Join. Participant. Sir, this is, yeah, we join participants, get teachers to start. Sure. Participants. This was the.